Hello, I'm Brad Hamilton, a shareholder with Jones Keller PC in Denver, Colorado, and today I'm going to talk about the importance of contract language. Clients sometimes wonder why their lawyers will spend so much time working on the exact words in a contract and whether those words are really that important. I see this in particular when a client sends a form contract from a vendor for review. They hope the lawyer will give it a quick look and say it's fine, or make a couple of corrections and move on. But sometimes those contract forms are so bad that they can't be used and they have to be rewritten, and the reason for that is not always easy to explain. So I'm going to explain why those words are so important. So I'm sure you know some people like to do a contract or an agreement on a handshake. Many contracts do not have to be in writing to be enforceable. Of course, if the contract is not written and the parties disagree on anything, how will they prove what the terms of the contract are? It will be one party's word against the other, unless there's other evidence like how the parties behaved after the agreement that can support those arguments. But people's memories tend to change to fit what they want to happen later. So a decision on what the deal was, if it's done on a handshake, will come down to who the judge or jury believes. It's a classic she said, he said scenario, which can be no better than a coin flip. So when a client tells me that a handshake is good enough because they trust the other party, that completely misses the biggest risk of any agreement based on trust. What if the person they trust is no longer there, or gets dementia, or is incapacitated, or anything happens to that trustworthy person? Who will the client have a contract with? The spouse, the kids, more distant heirs, a receiver, a bankruptcy trustee? Probably someone who has no knowledge of what the trustworthy person promised and no incentive to preserve that relationship you relied on for your handshake deal. So every agreement that will be performed over time should be in writing so that it can be enforced if something happens to one of the parties. When you put that agreement in writing, why are the words so important? Well, there's several rules that we lawyers apply to contracts. Rule number one, if the language of a contract is clear, explicit, and unambiguous, no additional evidence can be considered. If there's a dispute, the judge or jury will determine what the contract says and whether a party has breached or defaulted the contract based solely on the words in the contract. They can't consider and won't even listen to the parties testify what they meant or what their intent was or what they think the contract says. The contract language speaks for itself. End of analysis. But if the words are not clear or confusing or there's a mistake, then the court can't rely solely on the words of the agreement. It must determine the intent of the parties. There are two general factors in determining what the parties intended for the contract. The first one's called parole evidence, and the second are a whole bunch of rules of contract interpretation. And either one of those might not result in the outcome you want or expected when you entered that contract. So the first one, parole evidence, means evidence from outside the words of the contract. If the court is considering parole evidence, now each party can testify what they think the contract means and what they intended when they entered the contract. And in that case, it may come down to which party is most believable. And as I mentioned before, people tend to remember things the way they want to when there's a disagreement. In addition, the court has rules of contract interpretation. that it can apply to decide what the confusing language means. There's several of those rules. Rule number 2, precatory terms are determined to be not written. So what that means is, precatory means words that are expressing a wish or a desire or intention, as opposed to an obligation, words of obligation like, one party shall pay $100 to the other party. Vague language or description language or requests are not considered by the court if there is an ambiguity in the contract. They completely ignore those words. The court will only consider plain statements of obligation. That's one of the rules of contract interpretation. Now we get into the Latin rules. That can't be good. Rule number 3, ejusdem generis. General words followed by specific are limited by the specific words. So for example, if a contract says, I hereby sell to you the minerals and the oil and gas rights, and then their dispute, did minerals mean gold, silver, uranium, or did minerals mean oil and gas rights? Well, under ejusdem generis rule, minerals is further defined by oil and gas. So minerals in this case means hydrocarbons. What if that's not what the parties meant? What if they meant to sell all minerals plus the oil and gas? Now you have a conflict that's going to be resolved against one of the parties. Another rule of contract interpretation, and we're back to Latin again, inclusio unius est exclusio ulterius. Inclusion of one is exclusion of the other. Does that sound like the opposite of ejusdem generis? Maybe it can be sometimes. This one means that if you list a bunch of things that the contract addresses, then that means it doesn't address things that aren't listed. That's why lawyers, unfortunately, are fond of writing including without limitation whenever they write a list. Another rule of contract interpretation, this is rule number 5, is that confusing language is interpreted against the party that drafted the contract. If your lawyer wrote the contract and she included confusing language, you lose. Those are a few of the rules, and I won't bore you with more of them, but you can start to see the problem. In a dispute about unclear contract language or a mistake in a contract, there are rules of interpretation that may be applied and have nothing to do with what the parties wanted and might cause an outcome that at least one of the parties did not intend. That gets pretty technical, so let me provide a couple of 2-letter examples, one simple and one more dramatic. The first one is in versus of. There was a recent case where the contract said that jurisdiction for any disputes would be the courts of North Carolina. One party sued in North Carolina State Court. The other party wanted to move the case to U.S. Federal District Court in North Carolina, and the court said no. If the contract had said jurisdiction would be the courts in North Carolina, that would include federal court. But the contract said jurisdiction was the courts of North Carolina. A federal court is not a court of North Carolina, even though it's in North Carolina. Only state courts are of North Carolina. Now, to a much more dramatic case, a story known as How to Lose a Baseball Team Through Legal Malpractice. This involves also 2 letters, I-N, in, and E-X, X. In 2004, Frank and Jamie McCourt was a lawyer, by the way, bought the Los Angeles Dodgers and planned to move from Massachusetts to California. California has some very specific and unique divorce property laws. And so it's a good idea for very wealthy people to have an agreement about what assets belong to each spouse and what are joint assets, and the McCourts wanted to do that. They had lawyers at a prestigious law firm prepare what's called a marital property agreement that was supposed to clearly state what property belonged to Frank, what property belonged to Jamie, and what property was joint property. This is what the agreement said. I have to go to the paper for this one because it's too difficult to remember. Frank's separate property assets: stock, bonds, mutual funds, all securities, inclusive of the following: the Los Angeles Dodgers and Chavez Ravine and some other property and stuff. First, what was going through the lawyer's mind when he wrote inclusive of? I have a lot of basic drafting rules I use when I'm drafting, and one of them is, when possible, if you wouldn't say it, don't write it. Are you going to say, I'll have a cheeseburger inclusive of tomato, lettuce, and French fries? No, you are not. So why would you write that in a very important contract? But it gets worse, much worse. There were 6 originals of this agreement. 3 of the marital property agreements said, inclusive of the LA Dodgers and the stadium. But the other 3 agreements said this: Frank's separate property, stocks, bonds, exclusive of the following, but including within this exclusion the Los Angeles Dodgers and Chavez Ravine. Are you shaking your head? I'm shaking my head. I have no idea what that means. Neither does anybody else. Exclusive of this stuff, including within this exclusion. That's what the other 3 agreements said. So there were 6 versions of the same contract, but 3 were different from the other 3. Now, I don't know what was going on here. This was before cannabis was legal in California, or I would assume maybe some THC was involved. All the lawyers had to do was make 3 lists: Frank stuff, Jamie stuff, joint stuff. There was absolutely no reason to write inclusive of, exclusive of, or including in this exclusion exclusive of. It just was completely unnecessary. The McCourts divorced. Frank claimed he owned the Dodgers. Jamie claimed she owned half of the Dodgers. Jamie won when the court threw out the marital property agreement on several grounds, including that it was so poorly written that it did not meet the requirement of a full and knowing waiver of property rights under California law. And because also the lawyers had a conflict of interest because they didn't tell Jamie they were representing Frank and she should get her own lawyer. According to Frank, he lost 1/2 of the Dodgers over 2 letters, inclusive versus exclusive. And he had to buy Jamie out of her half of the Dodgers. And he sued that law firm for malpractice. I think Jamie sued them too. That law firm no longer exists. So while that is a dramatic example of how a mistake in 2 letters and some very bad legal writing in general can have a huge financial impact, these stories and cases are common, and the case law is full of similar outcomes caused by confusing language or writing mistakes. That is why good lawyers spend so much time and pay so much detailed attention to the words of your contract so that when you buy the Los Angeles Dodgers, you won't lose them. Thanks for watching.